Welcome to an emergency podcast for advisory opinions. The Supreme Court finally released the decision in the Harvard and North Carolina affirmative action cases. We will talk about it. They also released the case in Groff, that religious accommodation case. We will get to it. I'm Sarah Isgur. That's David French. And this is Advisory Opinions. So, David, just a few. Can we do some housekeeping?
For sure. Yeah.
One, there was a story that came out today that's making the rounds about that in 303 Creative, this is the case about whether a website designer needs to make custom wedding websites over her own religious objections to LGBTQ weddings. And in part of that lawsuit, she claimed she'd gotten a request for a wedding website. An intrepid reporter actually made a phone call to check in with that guy, see what he's thinking on the eve of the decision. And he was like, what are you talking about? I'm a straight man, have been married to a woman for years. I have kids. Obviously, that wasn't me. I've asked Alliance Defending Freedom, who are the lawyers who actually signed the pleadings in that case, for comment and update. When I get it, hopefully by tomorrow, when we get the decision, we'll wrap that into our 303 Creative case. Until then, I'm actually going to just even skip all the details. We're just going to put that all to tomorrow, but I'm aware of it. Second housekeeping detail. Article 3 of the Constitution says the judicial branch of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. This was mentioned to me a few times by listeners when I suggested that perhaps if a Supreme Court justice recused and we encouraged more recusals, which I'm not in favor of because of the general litigation games that can be played with recusals, that we do sort of a roulette of chief judges from the circuits. And people were like, wait, y'all, that unconstitutional. I see your point. It might be. I think it's easily fixed. When you confirm a circuit judge, you could maybe perhaps add something about this designation, or perhaps when they become chief judge. I don't know. I don't have a perfect fix to this. That idea itself was from a very smart lawyer who sent it in. But okay, I get it. There's a problem. So then I'm back to disfavoring recusals. I don't mind.
Yeah, well, and one thing I would say about this is there's a lot of constitutional deference to the branches of government governing themselves. So huge constitutional deference if the House of Representatives wants to toss somebody out, in spite of the fact that, they are designated to be elected representatives, but they can be tossed out by the House. So there's a lot of constitutional deference there. There's constitutional deference in how the Supreme Court drafts its own rules to govern itself. So I'm not giving up on your idea yet, Sarah. I had never heard it before, and I like it, and I'm sticking to it.
I also would say there's a difference between, if it said shall be vested in 9 Supreme Court justices, that would be kind of a deal breaker. But one Supreme Court, without specifying what makes up that court, again, I think could be pretty easily fixed in the confirmation process for circuit judges, along with your deference point, David. Last housekeeping point, and I experienced my first pregnancy privilege yesterday, David. And remember, This is my second pregnancy, but my first public one, because COVID hit by the time that you could tell I was pregnant. And then I didn't get to leave the house until, well, I guess I did leave the house in June for the pregnancy. And then they just sent me right back home. So I was on the train from New York to DC yesterday. And literally everyone on the train car was like, how can we help you? Where would you like to sit?
Well, isn't that nice?
Well, at first I sort of forgot I was pregnant. I was like, wow, well, these New Yorkers just so nice all of a sudden. And then one guy kind of, gestured towards my midsection. I was like, oh, right. Yeah, I'm fat. Got it.
Well, public decency still exists.
And in New York, of all places.
Yeah, absolutely. No, that's encouraging. I'm glad to hear that the mores of Twitter have not completely infected the rest of America.
It was quite lovely, if weird and disconcerting at the same time. Okay, Harvard case, enough housekeeping. Let's get to it. David, it was a 6-3 decision. You have the Chief Justice writing. You've then got concurrences by Justice Thomas. Very long concurrence.
Yep.
Justice Gorsuch, interesting concurrence on the statutory side of things. Justice Kavanaugh, no, we're not overturning precedent. And then you've got the main dissent by Justice Sotomayor, as well as another dissent by Justice Jackson, only in that North Carolina case. David, this looks remarkably as was expected.
Yes. I am surprised how unsurprising this is. I was ready for somewhat of a surprise after the Alabama and Indian Child Welfare Act cases, and it didn't occur. And I think there's a good reason why why we can articulate why it didn't occur. But the bottom line here, Sarah, is that if you support race-based affirmative action, this was not the case you wanted at the Supreme Court. And the opinion in the case made that, and the concurrences made that really, really clear. Because what happened in essence is that Harvard said, okay, we've got a tradition here that overwhelmingly benefits wealthy white people. We're not going to disturb that true tradition. It's going to result in a class that doesn't exactly look like America. So we're going to fix that by engaging in invidious discrimination primarily against Asian Americans, a historically disadvantaged minority. So we're going to cling to cling to this legacy admissions world that disproportionately benefits wealthier white people. And to make up for the lack of diversity, we're going to engage in invidious discrimination. That's not the posture you want to have when you go into the Supreme Court of the United States. And quite frankly, Sarah, after 45 years since the Bakke decision in 1978, if that's the best that the university system can do, if this is what 45 years of race-conscious affirmative action ends up looking like, then good riddance to it. Because it looks an awful lot like invidious discrimination, and specifically invidious discrimination against a historically disadvantaged minority that has faced race-targeted immigration restrictions, race-targeted segregation, race-targeted internment during World War II. I mean, come on, what are we doing here?
All right, so 6-3, they strike down Harvard and North Carolina's admissions programs. But the headlines have been a little mixed. It's ranged from Supreme Court upholds Bakke and Grutter, the two previous main precedents on affirmative action, to Supreme Court limits use of affirmative action. I kind of think that one's the most accurate myself, but I want to turn this over to you. To Supreme Court overturns affirmative action, with the implication that, look, they can say they didn't overturn Bakke and Grutter all they want, but they absolutely did.
Right.
Let's just stick on this for a second. How narrow is this decision? How big is this decision? What do you think?
It's big, but it's big in a way that you might not be able to. Let me put it this way. It's big, full stop. At the same time, it is not going to work a revolution in college admissions. So let me put it like this. What has happened is the Supreme Court said, if you cannot use race as a means of achieving diversity. You can use race if you've been in certain specific ways. So if you've been subjected to specific examples of racial discrimination and you've overcome that, well, you can articulate that in an application for admission and have that considered as a plus factor that you've overcome specific discrimination. If you are a victim of discrimination, there can be a race-conscious remedy for you as a victim of discrimination, outright victim of discrimination. Or you can change the criteria with which you can have affirmative action, but instead of race-based, it can be class-based. In other words, people with lower degrees of household wealth, for example, can receive a tip or an advantage. And so in many different ways, there are many different ways for universities to achieve diverse classes. And so it's not as if you go to Harvard, where they traditionally considered race as a factor, versus going to Berkeley, where they're banned from considering race as a factor, that you would say, well, Harvard's diverse and Berkeley is super white. No, that's not the case. Berkeley and University of California system schools are quite diverse, even though they're not permitted and have not been permitted by state law to use race in their affirmative action calculus. And so you're still going to see diverse universities. It's just going to be diversity based on different criteria. And many times those different criteria will end up having a very similar effect as race-based affirmative action, but it won't be race-based affirmative action. And I think that, so that's the top big part of it, is you just can't do this race-based affirmative action. But the subhead of that is that does not mean that universities have no flexibility to create diversity. They still have an enormous amount of flexibility to create diversity. It just can't use race as the proxy. It can't use race as the criteria for adjusting class composition.
Interesting. I don't know that I agree with all of that.
What part do you disagree with, and why are you wrong?
Yeah. So let me walk through, I want to walk through sort of the best arguments I've heard that are totally contradictory, and yet all of which are at least supported in part in the majority's decision. And I'm including the concurrences in that as well. Okay.
Right.
So argument number one, this was an incredibly narrow decision. It upholds Grutter. It upholds Bakke. What it does is say that Harvard and UNC violated Grutter and Bakke. So Bakke and Grutter, by and large, say that you use strict scrutiny. There is a compelling interest in having a racially mixed class of students. You just can't use a quota system. It has to be a holistic application process where you look at the individual student and see whether they're contributing said diversity, including racial diversity, to your class. And what you can't do, and this is now taking more from Grutter, is the quota system, because the quota system by definition then stereotypes someone that just because their skin is a certain color, they've had X experience that you think they should have had because of their skin color. And so what the Chief Justice has said is Harvard and UNC violated Grutter. They may not call it a quota system like they did in Bakke, which was a set aside for the medical school, but it was. Just because they hid it behind fancy language, the record is quite clear. The record's quite clear both in terms of what they were saying to each other in the admissions office and in terms of the actual numbers that we know of, where every single year they have the exact same percentage of every race. That's a quota system. It violates Grutter. Your admissions policy, however well-intentioned, and maybe it wasn't well-intentioned, violates our precedent. Okay, so this was a very narrow decision. I think there's plenty of language to support that in the Chief Justice's opinion. Well, let me give you the next one, which is, wait a second. What Grutter and Bakke actually said was that the reason that these admissions policies could satisfy strict scrutiny is because there was a compelling interest in having diverse educational experiences. And you're talking about Grutter and Bakke a lot, but what about Fisher too? That's the University of Texas case that was decided after Grutter, where they upheld Texas's holistic admissions policy that clearly took into account race and was, sort of the next test after Grutter. Harvard and North Carolina look a whole lot like Fisher. So why was Fisher upheld and this not? Clearly, we did just do something pretty dramatic to the use of race in admissions. I think there's something to be said for that, because the Chief Justice very clearly says that diversity in education does not satisfy strict scrutiny as a compelling interest anymore, which is pretty much what Grutter and Bakke had said. Then you have Kavanaugh's opinion, the concurrence, where he's listing all of the ways in which this is actually upholding Grutter. You have Thomas's concurrence, where he's like, I would overturn Grutter, but fine, whatever y'all want to do. The point is, I think you kind of did overturn Grutter, and I'll just sit back and pretend we didn't, if that's what you really want. And he, and I hope we'll spend some more time on Thomas's concurrence in general, because Thomas walks through the history of the 14th Amendment in his eyes, whereas you're going to see the history of the 14th Amendment very differently through the dissent's eyes. And in a way where, David, I would say that they're not even agreeing on some of the basic universe of facts, which you don't often see in a Supreme Court opinion, where like they're just in different universes entirely. It's not like, well, here's this, and I disagree on this part, and I disagree on this part. It's like, nope, two different worlds being described in Thomas and Sotomayor and Jackson. And then Gorsuch, in his, is like, look, good news, bad news. Even if this didn't violate the Equal Protection Clause, which it does, it definitely violates Title VI of the Civil Rights Act. And let me tell you the reasons why. And also, let's get into some of what this record actually said. These schools say they're interested in diversity. That's interesting because they're using check boxes on race that are somewhere between meaningless and gross. Meaningless in the sense that they don't differentiate between the descendant of a slave who might have actually been forced to build the school in question versus very wealthy Nigerians. I don't know why everyone keeps picking on the Nigerians, but so sorry to the country of Nigeria. And he mentions, and Asians, on the other hand, again, one checkbox, are 60% of the world's population as defined by that checkbox. So someone whose great-grandparents were in Japanese internment camps is checking the same box as someone from Iraq, is checking the same box as someone who is Filipino descent, by the way. He's like, what in the world are these check boxes? They're so pointless. And like, get to the Hispanic and Latino thing. And then and this is where I'm getting to for that third bucket, right? It's a super narrow decision. They violated Grutter and Gratz. It's actually a much broader decision. They did overrule Grutter. They just didn't say it. And then my third bucket is these admissions counselors were incredibly lazy, as all admissions counselors have been, because they've been able to use these rough, gross check boxes. And that, in fact, we told them to use holistic admissions processes. They've been half-assing it since then. And by God, we're going to hold them to it, because you can look at this record and see what they actually think about all of this. And it's awful. I mean, we've talked about the record before in this case, David, but Justice Gorsuch points out some of the grosser comments in his concurrence, where they say, oh, he's got good grades for a Native American kid. Or, oh, look at this SAT score and all these activities. Oh, wow, great. Yeah, but it's an Asian kid. Too bad. Where they're just using race as these, again, incredibly blunt instruments, but they're doing it to be lazy because they're going to fulfill this basically quota system that they have. And so my third one is somewhere in between the two, which is, hey, admissions offices, use race. You just can't do it with these check boxes because, frankly, it's turned you into monsters who are absolutely discriminating against people, even the people who you think you're helping. The way you're talking about them, the way you're treating them is disgusting. But also, in result, what's happening is that you're just accepting the rich kids into Harvard and then touting the Benetton ad version of this, where like, well, yeah, but it's a rich kid with different skin color, patting yourselves on the back. Obviously, you can tell from my tone of voice, I kind of like the third version the best, which is just the do better. None of the opinions actually mention the concept that was brought up multiple times during the oral argument, that you could still ask, are you the descendant of American slaves? Clearly, that would have race involved in it. But according to, what I'm reading here, 237 pages of it, I don't see any problem with that checkbox, at least for a majority of the court. Now, we didn't hear from Barrett and Alito, for instance. But David, do you think that survives?
So I guess I'm confused because I think your third option is exactly what I just said.
Well, what I heard from you is like they'd have to write an essay about how they overcame discrimination in their school or something like that, instead of writing their essay about how they won the robotics competition. And that like I don't think that that's necessarily required. I think schools can do all sorts of other holistic admissions processes that take into account race. They just can't use check boxes and quotas.
See, I don't see that in the opinion. So if you're talking about just race, like just race, in other words, unrelated to any other life experience, in other words, not because of my race, I faced discrimination, or I faced this horrible incident with a police officer, or because of my race, growing up in this part of the country, I faced continual mockery or racial epithets from my classmates. If it's just race with nothing else as a plus or a minus, I think that's out in this opinion. It's just hard for me to see a justification for saying race, regardless of any experience connected to the race, is going to be able to be a plus or a minus. I have a hard time seeing that, as opposed to saying, look, for sure, race can be considered as a factor in admissions if race was a factor that can be articulated in a specific way in my experience growing up, or my experience in academics, or you name it, which is not saying that's sort of under the rubric of any person, regardless of race, who has faced adversity or challenges for whatever reason. And sometimes it could be related to race. Sometimes it could be you're as white as the whitest person alive, but you grew up in a double wide with no dad and meth addicted mom. And that's going to be a factor that can be included. But it's just hard for me to see that independent of any
about
other
the descendants
thing.
of slaves. That's clearly a race-based category. And I actually, to bring in the dissent a little bit here, Justice Sotomayor speaking, I thought very persuasively about the 14th Amendment and the immediate history of the 14th Amendment. Yes, some of it was about the descendants of slaves, but some of it actually didn't make that distinction.
There's an awful lot of Black Americans who are not descendants of slaves. They're descendants of African immigrants, or
exactly.
And so that is not a specifically race-based distinction. Descendants of slaves is based on status of the fact of slavery, which was absolutely a race-based institution in the United States. But in theory, if you had a Native American who was enslaved, they could benefit from that as well. And if you're a Black and you're not a this
is brought up at the oral argument, and when it was asked of the petitioner, the people who wanted to overturn these admissions policies, he would say, yeah, of course that's a race-based distinction. Just because it doesn't include everyone of that race, it certainly excludes people who aren't of that race. So, maybe we're saying the same thing, but I think you can still have a checkbox for that even. Like, I don't think you have to mention that in your essay.
For descendants of slaves? Yeah, but that's not. But again, the issue is that the key issue here is the status of descendants of slaves, not the key issue is not skin color. So that you have a whole category of people who are Black or brown or, whatever race, who are not part of that community. And so it's not a race-based distinction specifically.
I hear you. I think it both is and isn't. I think, if, for instance, if you said we're not going to hire anyone who's the descendant of slaves, we would say that was a race-based distinction. It was racially discriminatory. We wouldn't say, well, they're happy to hire other people who aren't descendants of slaves who happen to also be Black. We'd say, like, no, obviously you can't exclude someone because that is going to be excluding people of a certain race, even if it doesn't exclude all of those people of a certain race. Can I give you my really extreme thing that I think? I don't know. If I were some school, maybe I'd be interested in trying it.
Okay.
A lot of the emphasis here was on, again, the bluntness and arbitrariness of these, 7 checkboxes? I can't count. I think it'd be very interesting if a school actually did affirmative action the right way and actually said, like, there are specific things we think will bring diverse perspectives to our school. Please check here. If one of your parents did not attend college, please check here. If you're the descendants of African slaves, please check here. If your parents immigrated from one of these 15 extremely impoverished countries in the last 20 years, please, so like you were, some of that's going to be race-based. Some of it's not going to be race-based. I don't know. I think a school could do that based on this opinion, or at least make a argument that they weren't violating this opinion in trying it.
No, I agree with you. But none of that is saying, while it has race disproportionate effect, it is race blind as a criterion. And so, in other words, what this policy leaves in effect is in my view, if you have standards that are not specifically race-based, but still have race disproportionate outcomes, you're going to be in good shape so long as you're not you're not using the race neutrality with race disproportionate outcomes as a cover for invidious discrimination. That's the Thomas Jefferson case, where you're sort of saying, well, we really need fewer Asians, but we can't say fewer Asians, so therefore we're going to and that would be one of your arguments against a company that said, we're going to hire everyone is eligible to work for us except descendants of American slaves. You would say, whoa, wait a minute, this is a fate that appears to be something that is not directly related to race, but is absolutely disguised invidious discrimination. And
can I give you the even more extreme example?
Yeah.
I'm going to take it one step further. The school says, all right, look, yeah, this Asian category that covers 60% of the world's population, we get it. That's not going to work. But in truth, we would love to have more Iraqi students who we think do have a specific experience, especially given the war, of the last 20 years. And frankly, because we've just been using this blunt Asian checkbox, we're getting too many students of Chinese descent. So yeah, we're going to ask for specific, whatever you want to call it, national origin, blah, blah, blah. And we're going to use like really narrowly tailored to make a diverse body. It's not that we're going to have the same percentage of Iraqi students every year or even of Chinese students, but we do want to make sure that we aren't getting, of our 20% of Asian students, we don't want all of them to be Chinese. We want to make sure that they're in fact covering more of the waterfront. What do you think of that? And by the way, my stated purpose is both to increase diversity at the school and the educational experience, and also to ameliorate past discrimination, which is why we're really looking for students of those Japanese internment camps or students of Iraqi descent. I'm going to list off some that we think are particularly have faced past discrimination in the educational process in the United States. Both.
I think if you're tying something to a past descendants of slaves, descendants of those interned in internment camps, children of Iraqi and Afghan interpreters, if you're talking about categories where you can say, here is a specific historical phenomenon, whether it's relatively recent past or further in the past or quite contemporary, like children of Afghan and Iraqi interpreters, that you can tie that beyond just skin color. If you say, well, we're going to have anyone who's of Iraqi descent. Well, okay, mom and dad are heart surgeons in Connecticut. And so therefore, there's our Iraqi checkbox.
It's kind of my question. Like, part of the majority here was saying that those checkboxes were too blunt. They were over and under inclusive. I wonder if you just made more narrow checkboxes, whether you could argue that you fit the narrow tailoring, you'd fix your compelling purpose problem. Yep, you're going to get rid of the legacies. So, to walk through some of the other complaints, and again, this is specifically taking from the Gorsuch concurrence, he walks through the checkboxes being too blunt, not narrowly tailored, and the fact that 5% of the applicants and 30% of the admissions at Harvard are either legacies or athletes, which are not just disproportionately white. That undersells how basically white students have been getting affirmative action, and they still will.
Yeah. Oh, yeah. I think even narrow check boxes that are explicitly racial are going to be out.
Maybe.
If they are on their face racial, in other words, or on their face national origin.
Yeah.
Every single person who is from Mali.
I'll make it Middle Eastern. Yeah, whatever you want. Yeah, race or national origin. There's ways to come up with both of them, but I make them really narrow.
Right. I have a hard time seeing them survive this. I think if you tie it to specific, if you tie something to specific, and again, we're not deciding this in a vacuum, right? Because we just had the Alabama case where you tied a race conscious remedy to a specific history in that state, but that does not mean that a race conscious remedy is going to be okay in all states.
David, okay, wait. So this is my last follow-up on this one. Harvard has a specific history of discriminating against Jewish students. I get that everything's fine now. So, you have to almost kind of ignore that part. But what if they just said, yeah, we're going to actually now have a plus up for Jewish students to make up for the discrimination that is explicit in our admissions policy back for their grandparents?
See, this is interesting because I think if you actually read carefully when it's talking about remedying a past history of discrimination, a lot of the arguments from these schools are societal discrimination.
Correct.
Not the specific institution.
Which is weird because the specific institutions have plenty of history of racial discrimination. Plenty.
Right. And so I do think if you had something that was much more along the lines of Alabama in voting rights, and it was instead of Harvard and how it discriminated in its admissions, it specifically did, that might get more interesting. That might be an exception to my no checkbox, but it would be a checkbox based on the specific actions of the school and the community the school specifically harmed. Yeah.
But look, in reality, like you said, what I think most schools are going to do is move to something more like a California, Michigan, Texas model where, and this could be the very best outcome in some respects. Look, I actually think diversity in education is important. And as we've talked about before, I don't think socioeconomic status is a substitute for one's experience as a racial minority in this country. We don't want schools where you fill all of your rich kids with white people and all of your poor kids with not white people and say, look, diversity. That's actually not diverse either. Lots of poor white kids in the country, lots of middle class and wealthy non-white kids in the country. Actual diversity in an educational experience can't only be socioeconomic. And so that's actually the last thing I would sort of want all these schools to do, which would again be the next laziest option that they could pick. So some of them will, no doubt. But, you get rid of all the legacy admissions and the athletics, getting in for athletic competitions that are not necessary. I'm not saying they're not great, but they're not necessary. And then, of course, you have the dean's list. So there were these three categories. Legacy, which they argue helps their financial bottom line. For some schools, no doubt, there is some real difference on the margin for that. For Harvard, I think we can all agree they're doing fine. They could, end that. The athletic one. And then the dean's list, which is the nice word for kids of famous people. Cool, cool. Yep. And they could change all of that. Not even get rid of it. Just make it less. If they halved the plus up that those kids get, they would basically fix their problem, which is incredible and so disheartening. So that's one reality that could come out of this.
Yeah, no, I agree with you completely. And, one of those stats that was really telling was recruited athletes are 1% of the applicant pool and 10% of the student body. And
Yeah. And they're not football players.
no,
I mean, and even if they were, but like they're also not. This is where you get to the varsity blues problem. It's the sailing club and the fencing club and the squash team and the racquetball team. Again, not diminishing the importance of those sports, but it's one thing for the school to say that actually a lot of our income derives from the football team or something like that. But like, really? The squash team? You're gonna turn down the kid who worked really hard at a disadvantaged school and has faced discrimination and all sorts of stuff for the racquetball player?
Or the fencer. And also, let's keep in mind who can really afford to invest their kid in fencing and sailing and rowing. And these are not your sandlot sports, right?
All right. We have so many more things to get through. Okay.
Oh, yeah,
we need
go
to,
ahead.
I want to touch a little bit more on the Thomas concurrence specifically and how it relates to the dissents. I want to get your views on that. And then we got it to the military footnote for sure. A couple more things to go. Okay. I want to read you the end of Justice Thomas's concurrence because I think it will go down as one of those parts of his legacy that will be relevant. The great failure of this country was slavery and its progeny. And the tragic failure of this court was its misinterpretation of the Reconstruction Amendments, as Justice Harlan predicted in Plessy. We should not repeat this mistake merely because we think, as our predecessors thought, the present arrangements are superior to the Constitution. The court's opinion rightly makes clear that Grutter is, for all intents and purposes, overruled. And it seems that universities' admissions policies for what they are: rudderless, race-based preferences designed to ensure a particular racial mix in their entering class. Those policies fly in the face of our colorblind Constitution and our nation's equality ideal. In short, they are plainly and boldly unconstitutional. While I am painfully aware of the social and economic ravages which have befallen my race and all who suffer discrimination, I hold out enduring hope that this country will live up to its principles so clearly enunciated in the Declaration of Independence and the Constitution of the United States, that all men are created equal, are equal citizens, and must be treated equally before the law.
It's good stuff. No notes.
10 out of 10.
10 out of 10, no notes.
But you compare that to Justice Sotomayor's version. And I read that from Justice Thomas, and I hear a lot of truth in that. Yeah. But I have to say, I read Justice Sotomayor's opinion, and there's a lot of truth in that too, which is that, as I mentioned before, the immediate aftermath history of the 14th Amendment was not always simply limited to those who had been held in slavery, but in fact was race-based at times. Their views of the Constitution, he describes it as colorblind. She says it's never been colorblind. The country's never been colorblind. It certainly isn't colorblind. And then even the language difference, right? He talks about equality. She talks about equity. It really is, it felt like such a modern fight that we're having in our political arguments. It's actually kind of rare to see that play out in the language of Supreme Court opinions. And it was notable to me, David.
Yes, no, and look, I think, and Justice Jackson's dissent also quite clearly laid out the consequences of centuries of racial oppression. And I don't, I understand, the one part, I would say 9.5 out of 10 for Thomas. I do have a slight note. I do completely agree that when the nation has engaged in racial discrimination, there is going to be a need for remediation, and specifically to the specific victims of that racial discrimination. And there are circumstances where the Supreme Court, as we've just articulated in commentary this term, Indian Child Welfare Act in Alabama, where the color blindness, this wasn't a purely colorblind situation. because there was a very explicitly racial harm inflicted, in many cases by the very institutions or by the very state, for example, Alabama, that was seeking newfound color blindness, right? And so I do think that there are circumstances where to remedy color-focused discrimination, there has to be a remedy that matches in the discrimination that was inflicted. But again, Sarah, I don't want to belabor this point too much, but that's not what the universities were arguing over. This wasn't what was at issue in the case. The issue in the case was not Harvard inflicted racial harm and has therefore put together a policy designed to ameliorate the racial harm that Harvard inflicted. It was diversity is great, and one way we're going to achieve it is through just a kind of a blunt force racial analysis of what diversity is and isn't. And so in some ways, I felt like the dissent was arguing a case that didn't exist, because the case wasn't about historical harm inflicted by these institutions. That just wasn't in the case. And so diving into that was sort of diving into an argument that wasn't the argument before the court in key ways.
And indeed, the majority, the Chief Justice, but also each of the concurrences is going to take issue with the dissent in saying, like, look, you're telling a great story, but it's not an issue in this case, or you're misrepresenting, for instance, there's the part where they point out that the dissent keeps quoting the dissents or the concurrences in Bakke, but not actually the majority opinion in saying what Bakke held. And it's like, look, here's how I know you're not telling the whole truth. You aren't actually quoting the majority. Here's another footnote 1 from the Chief Justice's opinion. Justice Jackson attempts to minimize the role that race plays in UNC's admissions process by noting that the school accepted a lower percentage of the most academically excellent in-state Black candidates, 65 out of 67, which would be 97%, than it did similarly situated Asian applicants, that is 1,118 out of 1,139, 98%. It is not clear how the rejection of just 2 Black applicants over 5 years could be indicative of a genuinely holistic admissions process, as Justice Jackson contends. Indeed, it cannot be, as the overall acceptance rate of academically excellent applicants to UNC illustrates full well. Over 80% of all Black applicants in the top academic decile were admitted. Under 70% of white and Asian applicants in that decile were admitted. In the second highest academic decile, 83% of Black applicants admitted, 58% of white and 47% of Asian applicants admitted. In the third highest decile, 77% of Black applicants, 48% of white applicants, 34% of Asian applicants. The dissent does not dispute the accuracy of these figures, and its contention that the white and Asian students receive a diversity plus in UNC's race-based admissions system blinks reality. The same is true at Harvard. African-American student in the 4th lowest academic decile has a higher chance of admission, 12.8%, than an Asian student in the top decile, 12.7%.
Yeah. I mean, that's just, and keep circling back to this because this is how we started. This really is what Harvard really did was put together a systemic an admission system that was systemically discriminated against Asian applicants. Like, that's what it did. That's what it did. And so this was not this was not some sort of benevolent system where race could only be a plus for somebody. That is not what this was. This was a system that Harvard might have benevolent intentions, but it was experienced by Asian applicants in a quite malevolent way. And I think that's, one of the absolute fundamental difficulties here. And that's what separates this. And it's interesting, Sarah, if you look back, so what was the Bakke case? The Bakke case was University of California, UC system. What is Harvard? Harvard's in Massachusetts. I do wonder how this would have developed differently if all of this case law was sort of spawned by the University of Alabama or the University of or Ole Miss's efforts to remediate past discrimination, where you could point to a history in those specific institutions that was really grotesque. And you could point to that in those institutions as opposed to very different institutions with different histories engaging in different kinds of conduct. And there's a lot of what ifs here on sort of the way in which these cases came up. But the one thing that I just keep circling back to is Harvard has a system when it walked into court where it preserved institutions that privileged white applicants, and it began to make up for the resulting diversity loss by discriminating against Asian applicants. That's not the posture you want to walk into court with. It is not.
So the version of the world painted by Justice Thomas and his concurrence versus the version of the world painted by Justice Jackson. There's actually a whole section in Justice Thomas's concurrence dedicated to refuting Justice Jackson. And I find it to be a really interesting colloquy. And look, this is 237 pages. I'm actually not going to suggest that everyone go read all of this. We point out when we think there's particularly well-written stuff going on. But what I will say is that if you start at page 49 of the overall opinion, which is part B of Justice Thomas's concurrence, where he just talks about Justice Jackson, and read Justice Jackson, I think that back and forth is illustrative of a much broader conversation that we're having as a country. And you have two very smart Black people with different experiences and different viewpoints having this conversation. It's worth going to read that. And really what it's going to boil down to is, again, something we've been talking about for decades in this country, David, which is, do you fix racial discrimination and stereotyping at the individual level, or do you fix it at a group level? And this is a conversation between conservatives and liberals about a whole host of things. Is it the individual or is it the group? And what's the fastest way? What's the best way? What's the most fair way? All of these we debate. Justice Thomas says, I, of course, agree that our society is not and has never been colorblind. But under the 14th Amendment, the law must disregard all racial distinctions. Yet Justice Jackson would replace the second founder's vision with an organizing principle based on race. In fact, on her view, almost all of life's outcomes may be unhesitatingly ascribed to race. This is so, she writes, because of statistical disparities among different racial groups. Even if some whites have lower household net worth than some Blacks, what matters to Justice Jackson is that the average white household has more wealth than the average Black household. And then he talks about his own experience growing up in the segregated South. I feel like people read that with very different eyes, David, depending on their own experience, right? Like where you stand depends on where you sit.
Yep. Yeah, and I don't think there's the way I put it, I have a piece up already in the Times about this, is that I think the reality is that the system that the Supreme Court created, or is a permitting still, one that takes class-based affirmative action, allows for class-based affirmative action, does in fact still permit American institutions to address the legacy of all of these centuries of discrimination. Because what is one of the legacies of all of these centuries of discrimination? One of the legacies is disparate wealth. Another legacy is disparate income. Now, these are not exclusive. In other words,
will you just explain for a second? Because I think that distinction is really important. And I think a lot of people don't then explain the difference between income, which we think of more as socioeconomic status, and wealth, which is more generational.
Yes. So, and actually the disparity in the racial disparity in the US is much more a wealth disparity than it is an income disparity. The income gaps are closing. The wealth gap is enormous. And so wealth is take all of your assets and subtract all of your liabilities, and you have your wealth. Most people, the bulk of their wealth would be, for example, in the equity in their home. Okay. So just to let's oversimplify this for the purposes of explanation. Let's suppose that you are a person, you're a white person who has had the benefit of being able to live basically wherever you want to live. There's no redlining in the past. There's no formal residential segregation in the past. And so your parents' parents had a house in a nice part of town that was worth a lot. Your parents inherited maybe that house or the equity in that house, and you begin to see how having that just a nice home, can result in large intergenerational wealth transfers and the maintenance and the building of intergenerational wealth. Whereas, let's suppose your grandfather you're Black and your grandfather was subject to redlining and residential discrimination. You never had an opportunity to build that wealth, to have that home to pass down. Maybe you suffered from discriminatory rules regarding lending. So even if technically you could live in that neighborhood, you couldn't get the loan. And
right. So you may be making $80,000 a year right now, same as the other guy. But the other guy had, help on a down payment of his house from his parents, and they got him a college counselor, and all this other stuff. And the sort of new person to the $80,000 didn't get any of that generational benefit. They're starting now in the hopes of being able to get something to pass on to their kids.
Bingo.
Totally different experience.
You might both make 80 grand a year, and one of you is renting. So that means you have no equity. And the other person owns a home, say worth $600,000 that they owe $450 on. They have that $150,000 of net worth that is available to them. And so that distinction the wealth income distinction matters a lot.
Okay. I want to talk about footnote 4 from the Chief Justice's opinion. The United States, as amicus curiae, contends that race-based admissions programs further compelling interest in our nation's military academies. No military academy is party to these cases, however, and none of the courts below addressed the propriety of race-based admission system in that context. This opinion also does not address the issue in light of the potentially distinct interests that military academies may present. So what does that mean? It means the court is saying, maybe the military academies can keep doing quota-based checkbox. Basically, none of this applies. And this was brought up in oral argument several times, the idea that the military academies, this was the Solicitor General arguing, have absolutely a need to have specific racial diversity in order to have that type of diversity in its fighting men and women, and that is a specific compelling interest that those military colleges and universities have. David, I guess I'm of two minds. One, I just want to know what you thought about that. Two, if we think it's pretty important for the United States government to have a diverse fighting body, which I agree, diverse officer corps, diverse enlisted corps, then why isn't it compelling to have a diverse body of business leaders, of doctors, of everything else that one gets with a college degree, in terms of then having wouldn't it be nice to have diverse doctors to serve diverse American patients? Wouldn't that be a compelling government interest potentially?
Yeah, I have a very different feeling about that footnote than I did the Clarence Thomas comment that we just gave, that I modified to 9.5 out of 10, a few notes. This one, I'm giving it like a 2 out of 10 mini notes. Mini notes. Look, okay, on the one hand, the court has long had a great degree of deference to the way in which the military governs itself, including the ways in which the military engages in control over service members in a way that would violate the Constitution in virtually any other institution in American life. That the military has a quite unique role to play in American life, and it is given wide latitude to carry out that role. Got it? That's the 2 out of the 10. The 8 that's missing is It's not a constitution-free zone, guys. The military, it has a lot of ability to engage in levels of control and pass policies and enact policies that would otherwise violate your constitutional rights if you were a civilian. It is not unlimited. And if the argument is, as Gorsuch made quite capably in his concurrence, that without doing sort of the race checkbox, you can still achieve enormous amounts of diversity, why is that different in the military academy context? Isn't it also true, or is it just simply a lack of evidence? In other words, that, well, this wasn't a part of the issue in the case. We don't have the same kinds of evidence in the record regarding how alternative forms of admissions can still achieve diversity objectives, so we're just leaving it alone. But heck, if alternative ways of achieving diversity that are not racial box checking work, wouldn't they also work for the military academies? But again, that wasn't part of the case, but I'm not a fan of that footnote, Sarah.
All right. Any closing thoughts? Do you think that this has ended the legal conversation over affirmative action for a while? Do you think we'll be revisiting this? We've talked about the Thomas Jefferson High School case of then having race-neutral admissions policies with the purpose of having a racial effect by limiting the number of Asian students getting into a school. We're also going to have a whole lot of universities experimenting with what their new admissions policy can be. And I think, as we laid out sort of at the beginning, there's the easiest, least litigation way to do this, which is to follow the California, Michigan, Texas path. There's asking additional essay questions, getting, minimizing legacy, athletic recruitment, stuff like that. I think there's also some lazy ways to do this. I think there's my checkbox version, which is leaning in to test the court on some of this, which I would find very interesting and not, bad. I don't know. Where do you think this is all ending?
So I think this is going to not settle a lot of questions. You're still going to have a lot of litigation around various kinds of more narrow box checking. You're going to have questions, what we're going to call the Thomas Jefferson or TJ adjacent kind of questions, which is, okay, is this race neutral policy with a race disproportionate effect? Is it actually enacted for purposes of invidious discrimination or no? I think that's going to be an issue. The other thing, Sarah, though, that we haven't brought up yet is what are the implications of this case for sort of the whole kind of DEI ideology and how it works in corporate America, et cetera.
Yeah, the Mansfield rule that we mentioned in the last episode, whereby law firms sign on to get Mansfield certified, meaning that basically they meet specific racial quotas when it comes not necessarily to their decisions on who to hire or promote, but on the pool of people that clients interface with, or on the pool of people considered for partnership, right. Things like that, which is interesting, though definitely a quota system. It's a percentage-based system. The Rooney rule, there's the narrow Rooney rule, which is the NFL itself, and for head coach positions, which I think meets your very specific historical exception because the NFL itself did discriminate in that hiring for those jobs.
Yep.
But the Rooney rule across corporate America, different.
Nope. Yep. So I would put it like this. If you have a DEI program at your work that is just flat out race-based, in other words, we have a scholarship program only for Black students, or we're going to have diversity training and we're going to have a white affinity group and a Black affinity group. These are kinds of things that happen. If it's just flat out race-based, that's not going to fly by and large unless you can do something like what, Sarah, you just said about the Rooney rule. Hey, this institution specifically discriminated against Black applicants in a specific way, and this is designed to redress that specific discrimination. I think you're going to still be okay. But if it is a broad race-based classification because of diversity in general or whatever, this is going to cut the teeth out of a lot of the more extreme sort of versions of DEI ideology.
All right, we're going to go on to Groff, but before we do, I do want to read the last paragraph of Justice Sotomayor's dissent. Notwithstanding this court's actions, however, society's progress towards equality cannot be permanently halted. Diversity is now a fundamental American value, housed in our varied and multicultural American community that only continues to grow. The pursuit of racial diversity will go on. Although the court has stripped out almost all uses of race in college admissions, universities can and should continue to use all available tools to meet society's needs for diversity in education. Despite the court's unjustified exercise of power, the opinion today will serve only to highlight the court's own impotence in the face of an America who cries for equality resound. As has been the case before in the history of American democracy, the arc of the moral universe will bend towards racial justice, despite the court's efforts today to impede its progress, citing Martin Luther King, Our God is Marching On speech, March 25th, 1965. All right. I want to talk about the Groff opinion. So we've talked about this several times. We said it was going to be one of our top opinions. This was religious accommodation at the workplace. Our postal worker does not want to work on Sundays. And the opinion came out. We knew Justice Alito would be writing it, or rather highly suspected based on our bingo card that Justice Alito would be writing it. Indeed, he did. But what we did not suspect, A, that it would be a unanimous opinion.
Yeah, I know.
And that B, it would be so boring.
Yes.
There is no spicy Alito to be found. This is Alito at his most, his wife's friend's dinner party where he's on his best behavior.
This is Alito, not spicy Alito. This is buttered Wonder Bread Alito.
It's worth going back and talking about the Hardiman decision because the Groff in this case wanted the court to overturn Hardiman. The statute in question says that you must accommodate a religious practice unless it causes an undue hardship. But the court back in the 70s, in this case called Hardiman, basically said an undue hardship, yeah, that's anything more than a de minimis effort to try to accommodate that. If it is takes you more than a T-Rex lifting its little arms, then you don't have to accommodate it. And the unanimous court, Alito writing, basically said, yeah, we don't know where that de minimis thing came from. And frankly, it wasn't even a major part of the Hardison decision.
Yeah.
So look, let's call it substantial in light of the business that we're talking about, taking everything into account. And we're just going to send this back down because we don't know whether Groff and the Postal Service meet this on either side. Thank you for coming. Sorry, this looked like it was going to be a big decision. But Hardison is... Rather, they didn't overturn Hardison, but they did get rid of that de minimis language, which wasn't surprising given that nobody was defending the de minimis language in oral argument or in the briefs. David, what say you?
It's really interesting because after I read this decision, I'm kind of retroactively stumped as to why we thought it would be so big.
I know.
Especially since... Wait a minute, the Solicitor General didn't even really defend the de minimis standard.
I know, what were we thinking?
Nobody was defending the de minimis standard.
But it did wait until the end.
It did wait until the end, and it's a short, unanimous opinion with a short concurrence. And
I think it was one of the last decisions to be argued. It was one of the last decisions to be argued. It was about religious exercise, and we just got... I don't know, we got overexcited because Hardison was such a dumb, again, not even Hardison. There's one line in Hardison about the de minimis efforts. I don't know.
And there's parts of this that are essentially saying, look, you're going to have to try to accommodate. And then Alito says an employer who fails to provide an accommodation has a defense only if the hardship is, quote, undue, and a hardship that is attributable to employee animosity to a particular religion, to religion in general, or to the very notion of accommodating religious practice cannot be considered undue. So in other words, if I'm asking for an accommodation and the other employees are kind of pissed at me that I'm asking for an accommodation, that's not an undue hardship. But if you are having trouble filling in slots in, if you're having trouble staffing to meet customer needs, if you can make it concrete, then it can be it can be an undue burden. It sort of leaves it, honestly, Sarah, I don't know as a practical matter how much it's going to change the law.
I don't think it's going to, because I think Groff is going to lose this down below.
I think you're right.
Was creating an undue hardship. They were not able to cover the shifts. Even offering potentially small-ish sums of money, they were going to have to offer big sums of money, and even then it was hurting morale, and nobody wanted to cover the Sunday shift. So, look, that's going to be so record dependent. I don't want to get too far over my skis, but I think if this was Groff's chance to win, and he didn't win, it's going back down, I think he's going to lose. I do want to mention one thing. Justice Sotomayor wrote a concurrence, and there is an interesting, this is the only interesting part of this decision. Petitioner Groff asked this court to overrule Hardison and to replace it with a significant difficulty or expense standard. The court does not do so. That is a wise choice, because stare decisis has enhanced force in statutory cases. Congress is free to revise this court's statutory interpretations. The court's respect for Congress's decision not to intervene promotes the separation of powers by requiring interested parties to resort to the legislative rather than the judicial process to achieve their policy goals. This justification for statutory stare decisis is especially strong here because Congress has spurned multiple opportunities to reverse Hardison, openings as frequent and clear as this court ever sees. Moreover, in the decades since Hardison was decided, Congress has revised Title VII multiple times in response to other decisions of this court, yet never in response to Hardison. We're seeing a split this term that we didn't really see before of, well, look, maybe upholding precedent in the constitutional context does get messy. But when we're talking about statutes, Congress, do your job.
Yeah, absolutely. The way I interpret this case is basically this. Alito and the 8 other justices are saying, we're not overruling Hardison. We're just asking you to read more than the words de minimis. Because that seemed to be the only relevant words that a lot of lower courts were taking from Hardison was de minimis, when there's more to Hardison than de minimis. And so it seemed to be a more holistic, to use the term that we were importing from our discussion last case, a more holistic evaluation of Hardison seems to be what the court is saying. And one other thing about this, Sarah, how many supermajority or unanimous religious liberty opinions do we have to have before everyone can finally say religious liberty isn't hanging by a thread in the United States of America?
Probably a few more, if you're actually asking that question. Sorry, I don't know if it was rhetorical. I don't think...
Infinity more?
Infinity more. That's right. All right. We are expecting the student loan cases and 303 Creative to come out Friday morning at 10 a.m. The court hasn't announced that those opinions are coming out, but they're the only ones left, and they are releasing opinions tomorrow. Another interesting note is that the Supreme Court conference today, we are way behind in cert grants this term. The lowest that it's been going back to at least OT 15. So I'm expecting at some point that we're going to see some cert grants. They've got some qualified immunity cases pending, some other interesting ones that I'm sure we'll talk about if they're granted, several interesting ones that we're following. And last up, David, have you heard of nesting instincts? Like that women, when they're pregnant, like start nesting?
Oh, absolutely. Absolutely. I think we all have nesting instincts to greater or lesser degrees.
This poor second kid is getting all hand-me-downs for the nursery. Just nothing new for the nursery. But my nesting instinct kicked in for my own bed, and I went totally wild, like spending, I can't tell you how many hours. It would be embarrassing to tell you how many hours I researched sheets.
You know who has nesting instincts in a major way? Soldiers.
Oh,
So
yeah.
when we landed in Iraq in 2007, the energy and industry with which 800 guys set about carving out their own living space
Really?
was amazing.
Oh,
Yeah, everything from, using plywood to set up like separate spaces. And it was really interesting to watch just the sheer energy invested in creating a place of your own. It was kind of cool.
well, tonight will be my first night on the new sheets. I'm pretty excited. I'll report back. If it's awesome, I'll report back. If it's not awesome, I won't. But this is where all my energy has been going.
I love
is
it.
Waiting for Supreme Court opinions, and during the waiting, reading about sheets.
It's perfect.
All right. That'll be it from us today. Thanks for joining our emergency pod. Next time, we'll talk student loans and what do we call that? Free speech. What do we call those cases? 303 Creative.
Compelled speech.
Okay, yeah, compelled speech. Great. Cool.
Yeah.
See you next time.